As Jonathan mentioned, my name is Ezekios Evan Andronis. I'm the 24th skipper for Fort Lauderdale Mariners Club. I want to start off by thanking each and every one of you for coming today. Without you and the generosity of our sponsors, this event cannot happen. So I just want to give you a round of applause first. Thank you. As many of you know, the Fort Lauderdale Mariners Club is a non-profit, non-political organization devoted to the promotion of friendly associations among members of the marine insurance community. If you enjoyed the seminar today, I encourage you to also look at joining the club year-round. We have a monthly luncheon each Thursday, the first Thursday of each month, that includes timely topics such as changing the maritime culture one forecast at a time, investigating local boating accidents, the International Seakeeper Society using privately owned yachts to support marine science and oceanographic research, and a special speech from our friends at Spectrum Sailing. In addition to the monthly luncheons, we have different events that occur at different times to allow people to join in and network with social opportunities. Through these events, the club continues to strengthen its connections and find new ways to benefit its members and the community. Giving back is an important part of the club, and this year I'm proud to say that we donated over $15,000 to different organizations in the marine community locally. So if you're interested in joining or learning more about the Fort Lauderdale Mariners Club and what we do year-round, please stop myself, any of the other officers nearby, and I'm happy to speak with you about it. Otherwise, I hope you all enjoy the speaker today. We have a great lineup. And with that, I'd like to invite our seminar chairman, Ryan Emond of SEA Limited, to say a few words. Thank you.
Thank you, Evan, and thanks for your leadership of the club throughout the year. You've really made some great strides with you and your officers. I think we're looking forward to great things in the future. Thank you all for being here today. I think it's very important that you're here, and it's important to us. It's why we do the seminar. It's why we spend hours and hours finding the best speakers, the best topics, and the best venue here in Fort Lauderdale. And we work very hard to bring this to you. I'd also like to thank our sponsors who you'll hear about and see about throughout the day. It's about them this wouldn't be possible. But the group of people that I really want to thank the most are the folks that have been supporting me all year and really doing all the hard work to bring this together. That's the seminar committee. They spend hundreds of hours of their own volunteer time and no pay, but lots of alcohol. But we're here today because of them, and I could just stand up here and read a list of the names of the folks who worked so hard all year, but given how hard they work on our team with anchored algorithm, it might be something a little more special than that. So with that, our 34th Fort Lauderdale Mariners Club seminar committee.
Speaking of the Fort Lauderdale Mariners Club, Kevin Andrews. Arlene Michelle, Seminar Finance Coordinator. Facilities Coordinators, Craig Carter-Gainer and Juan Carlos Perez. Promotional items by Sherry Patton. Tom Whittington, Logistics Coordinator. Alex Oliver, Coordinator of Continuing Education for Insurance Professionals. Stephanie Wiley, Continuing Education Coordinator for Legal Professionals. Laura Sherry and Chris Coleman, Sponsorship Coordinators.
So this counts as
Social media coordinators, Michelle Otero Valdez and Jackson.
Probably it does, but he's really whatever you're it's more an educational outcome.
so if you're in Georgia,
It's not good. I don't know. I mean, you'll get them, you'll still know if they're credited to your accounts. Like mine, I have to have Louisiana credits.
And the moderator for the 34th Fort Lauderdale Mariners Club Insurance Center, Charlie Devine.
So thank you very much for being here. I'd like to introduce to you our moderator for today. He's been been skipper of the seminar. He's run the seminar. He's been the skipper of the club, and he's also been a contributing member of the seminar committee for over a decade. It's Charlie Bennett of Bennett Law.
Good morning, how are you doing? All right. Thank you, Brian. Iman, give it up for Brian. Big round of applause. As he said, the seminar committee actually starts. We have a meeting on November 11th to wrap up this seminar and start planning for the next one. So if you have any ideas about topics, speakers, anything that we can be doing differently, please come see one of us. And please also thank the seminar committee members. They're the ones that have the red badges on. And they'll be able to help you. They're also wearing these great blue, navy blue shirts that everybody has on. So please let them know of your comments, maybe just a word of encouragement, and definitely a thank you. So thank you, Brian, and the committee. Also thanks to Jonathan Dunleavy for the great welcoming remarks. And Evan and Jonas, our skipper this year, thank you for those remarks. The club this year is especially fortunate to have, as our 2024 keynote speaker, naval architect Peter Gumpel of Winchester Design Group. Peter, if you know, has been a panelist at this seminar for a number of years. He also authored an article that was featured in last year's program.
You never could do pen and paper.
Related to the Titan submarine loss and the Titanic wreck in the North Atlantic. Peter's going to be talking a little about that, as well as his views regarding the development, use, and application of technologies in the marine industry. I think we're all in for a real treat, so I encourage you to be here for that at 10:30. I know Jonathan talked about Poll Everywhere, which is what we've used in the past to get questions up to the speakers. We're not using that this year. We have an app, CVENS. If you haven't downloaded it, I'm sure you got a ton of emails. Sponsored by none other than Michelle Del Valdez. Did I say that right? Okay. And if you go into the section in the app, probably right now, since we're running a little bit behind, you should be able to pull it up, and there'll be a Q&A on the bottom. I will tell you that I'm the one that can see your questions, so if you guys play that, for better or worse. And so if you have a question and you'd like to send it, please send it through the app, or if you want to do the old-fashioned way, write your question down on a piece of paper. Usually, Captain Crystal is walking around and he's very nice. And the question, it will end up to the right person. Finally, I know that Jonathan gave you the day off from work, but we do have a Wi-Fi here in case you need to get to that anything. There is a firewall. There it is. Weston Meeting Room, Weston 2024 CC. I want to make sure I said that out loud. So if you get connected, that's how you do it. The Marriage Club is pleased to once again sponsor students in our audience from the University of South Florida who are studying insurance and risk management. This is something that the committee and the seminar has been doing for almost a decade, I believe, started by Art Campbell out of the FSU insurance risk program. I think there's a definite need in the insurance industry. I think all of us that are hiring and dealing with those problems can recognize that. So we'd like to encourage students to come and to be involved in the seminar. So Jacob Payne and Brian Hayes, if you're here, can you stand up if you recognize? There we go. If you see these two students, please go up and talk to them, engage with them, encourage them to be part of this great industry. That was coordinated by FLMC club member and seminar committee member Chris Coleman. Thank you, Chris, of Overseas Yacht Insurance. For doing that. And we thank our counselor, Christy Hoskin at USF, to make that possible. So please, again, welcome, Jacob and Brian. Thank you for being here. Just a reminder for anybody that's needing CE and CLE credits to sign in and sign out. And I will make one more announcement, and then we'll get to the program. I want to announce the Commodore sponsors. During the day, we're going to recognize the top 3 levels of sponsors. First, like to recognize the Commodore sponsors. So if I could please have a representative of the following companies, and there's a lot, to come up and receive an appreciation gift. Are you ready, Rebel? He's ready. Okay. So afternoon break, Star Marine, Colin Frazier, please come up. Morning break, Private Client Select Insurance Services, Len Algigi, please come up. As I'm talking. Golf drink cart, Scioli Alexander Pina, Sophia Usquana, please come up. The golf breakfast, Tokyo Marine, Val Santoro. Espresso cart, which I think we're all need the audience today. Markel, Crystal Jessup. Golf lunch, Crystal Capital, Specialty Salvage, Ron Alerta. The mobile app that I was telling you about, the law offices of Michelle Valdez. Seminar breakfast, Travelers, thank you, Christina Mayer. Also seminar breakfast, Atlantic Casualty Insurance Company, James Bass. And then finally, on our afternoon break, we have a law firm of Barrel Smith, David Smith. If he's here, please come up and grab your gift. And thank you to all those Commodore sponsors. So, enough talking. Welcome to the Fort Lauderdale Marine Insurance Seminar, the 34th Marine Insurance Seminar, Anchors to Algorithms. I'll welcome up our speakers, Michael Goldman and Alan Graham. We're going to be talking about marine insurance and maritime law, centuries old but recent changes in the industry. Specifically, the United States Supreme Court had a very close look that I know Michael's going to get into, Raiders Retreat, that has affected the entire market, the entire marine contract industry. So, on this panel, we have Michael Goldman, who's a partner at the Goldman Maritime Law Group in Boston, specializing in marine insurance coverage litigation across federal courts in the U.S. And we also have Tito Graham, a Pascagoula, Mississippi native, who combines his engineering degree and a master's degree in admiralty maritime law to tackle complex problems. So please join me in welcoming Michael and Tito for our first panel.
First, thank you, Charlie McMahon. Thank you, Captain Chris. Thank you to the whole Fort Lauderdale Mariners Club for this invitation, this opportunity to share good news. Having given this presentation a few times, I've learned that everyone pays better attention and understands better. If I start with a conclusion, which is this: to all the underwriters in the room, claims managers, adjusters, in-house counsel, and everyone else, the Raiders decision means that you can insert a choice of law clause in your policy of marine insurance, and you can pick a single state's law to fill gaps in federal liability law. So the first thing you need to do on Monday morning when you get back to your office and get your cup of coffee and you sit down with your pencil, and you put in a choice of law clause that picks one state's law. That way, when you issue policies everywhere in the country, no matter where, you can pick one state's law to fill gaps in federal liability law. And this goes for everybody, not just Great Lakes, not just surplus lines, carriers, everybody. Whether you insure canoes or supertankers, the Raiders decision means that you can enforce a choice of law clause. Now, take for example a policy that covers a vessel risk on Lake Michigan. Raiders means that you can insert the same safety conditions and enforce the same safety conditions that the main operator warranty, regardless of whether the policy is delivered in Wisconsin, Illinois, Indiana, Michigan, or Arizona. Because the choice of law generally is tied to where the policy is delivered to the insurer. Once you put a choice of law clause in, you can pick one state, no matter what state you delivered that policy to. Now, for the rest of you who aren't directly involved in marine insurance, Tito's going to go into this more, but I just want to say the Raiders decision is also extremely strong support, not necessarily binding, but extremely strong support for the position that anyone who has a maritime contract, which means something governed by federal and law, you also can put in a choice of law clause and rely on the rater's decision for it to be enforced. Now, to understand the import, you have to start with how we got here. In 1955, the Supreme Court decided the Wilburn Boat case, which I'll describe in a minute. And I'm sure many of you remember from my father's presentation over long in 2015. Before 1955, and starting with the Constitution, the federal courts have power over two types of admiralty matters: accidents that happen on navigable waterways and maritime contracts. And they're a little different. If you have a maritime accident on a navigable waterway, which means a waterway that you can either navigate to the sea or between states, you're going to have federal rules governing it. So you have the simplest collision between two vessels on the Mississippi River. It's going to be governed by federal rules apportioning liability. In contrast, you have exactly the same accident on the Great Salt Lake in Utah. The Great Salt Lake is not navigable. You can't get to the ocean or to any other state from the Great Salt Lake. So you're going to have Utah's rules on apportioning liability. The Constitution also gives the federal courts power over maritime contracts, which can be a little broader. And here's why. Any policy insurance covering a vessel against maritime risks is a policy for insurance, but that doesn't mean every single accident is necessarily maritime. One of the first cases I handled here was the Great Lakes, involving a vessel that was stolen on a trailer while it was on land. But it was a maritime insurance contract subject to maritime rules and maritime choice of law, because the primary purpose of the policy was to protect against nautical risks. The insurance policy doesn't even have to be on any particular vessel. A case I handled in Detroit a decade ago covered a company that leased a dock, and they had half a dozen different policies of insurance. One of their policies covered them when they damaged a vessel. It wasn't even one particular vessel, but any vessel they damaged was covered by this policy. That meant it could be that when there was a coverage dispute, it could be litigated in federal court and it was subject to federal law, or at least when there was no federal law, federal choice of law rules. And to give you an idea of what a paradise this was, you've all heard the phrase, the sun never set on the British Empire. Well, prior to 1955, the sun never set on a uniform body of Anglo-American admiralty law. The American courts went out of their way to keep American law in alignment with the maritime law of the United Kingdom and the countries of the former British Empire. In 1955, everything changes with the Wilburn Boat case, which involved a houseboat on Lake Texoma, which borders Texas and Oklahoma. The insured breached a private pleasure warranty. Coverage was denied because what everyone thought was the rule prior to 1955 was that warranties would be strictly enforced. And what that means is, if the warranty was breached, if the condition that required the insured to comply was breached in any way, the policy afforded no coverage regardless of whether or not the breach played any role in the loss. So, if you had a warranty requiring that the vessel only be used for private pleasure purposes, and you breached the warranty, and then a month later your vessel was abducted by aliens, that meant there would be no coverage for your alien abduction. So in this case, in the Wilburn Boat case, breach of the private pleasure warranty, the district court enforced the warranty, the Fifth Circuit enforced the warranty, both of them thinking that they were enforcing generations old uniform federal liability law. It gets to the Supreme Court, and the Supreme Court reverses and says, no. Not everything is necessarily governed by federal liability law. You have to apply a new test, and you have to ask, is there a specific rule of federal liability law pertaining to the precise clause or issue at stake? And if there isn't, you proceed to apply state law. I'll describe that more in a second. But what that means is you have to go issue by issue. You can't say that warranties in general are governed by federal liability law, or that some particular exclusion or clause or condition. You have to go line by line, and you have to ask your lawyer, please go back through the old cases. And if there's a case enforcing this, it'll be federal, but if there isn't a case enforcing it, it's going to be left to the states. And what happens is, over time, as marine insurance evolves, older clauses, like watchman warranties, for which that have a history in the reported case law, those are going to be subject to federal liability law. But new issues, as the industry evolves and develops new clauses, inevitably, there's no history to these. So there's nothing that the lawyer can point to and say, this is a rule of federal liability law. So over time, federal liability law withers, and more of these provisions wind up being governed by state law. Now, there's no general principle governing which. You simply have to go issue by issue. And the courts have held some issues, like the fortuity doctrine, the seaworthiness warranties, which we could, in another year's conference, we could go and we could spend an hour talking about each one of those, but I'll just briefly mention them here. Some of these are governed by federal law, and some of these are governed by state law. For instance, seaworthiness, certain warranties, like navigational limits warranties, are going to be federal. But other than that, almost every other warranty, like a named operator warranty or a fire extinguisher warranty, as we have in the Raiders case, all the express exclusions barring coverage for certain types of losses, all of these are going to be state. And one of the things worth mentioning, the Wilbur Boat decision does say that federal courts should consider whether or not to make use federal liability law. But as a practical matter, they're not doing it at all. A couple years ago, there was a case here in Florida, the Travelers in the Ocean and Charters case, where the district court here in Florida tried to create a new federal liability law, tried to say that this new warranty, captain and crew warranty, would be governed by a uniform rule of federal liability law. And when we heard the news in my office, we all said, well, big if true. It got to the 11th Circuit, and the 11th Circuit reversed the district court to extreme prejudice and held absolutely no. We're not going to, they didn't put this in words exactly, the effect. They said we're not going to allow federal liability law to continue to develop. So the practical result of that is that, I think I said a moment ago, if you have a risk, let's say a risk on ignition, the exact same risk, but the policy, you might have one policy delivered in Illinois, you might have another issued in Michigan or Indiana, the exact same risk, the law that's going to apply to things like the operator warranties, captain and crew warranties, the rule that's going to apply is always state. So imagine you're an underwriter. When you're issuing policies and considering risk, you have to consider the risks related to where the vessel is, who the operator is. But because of Wilbur Boat, you also have to consider what your legal risks are. And 50 different legal risks. So, into this chaos steps choice of law clauses. Choice of law clauses are very simple for the non-lawyers here. What they allow you to do is, you get to pick one state's law. So rather than having to worry about that Lake Michigan example, where you have the same policy issued in 4 different states, you can pick just one. Now, not every state is as good as every other, and ideally, since I represent the insurers, I want you to pick a very insurer-friendly state. But whatever you pick, it's at least beneficial for you to have to pick, that you can pick only one and not have to worry about 50 different legal risks. Now, this brings us to the Raiders case. The Raiders case involved a policy on a private pleasure craft. It suffered a grounding in Florida, but the insured was actually it was an LLC, but not actually a business. It's become common practice even for the owners of private pleasure craft to set up LLCs to own their boats, but they're not businesses. But the insured was an LLC organized in Pennsylvania, and the vessel was being navigated in Florida and suffered grounding. Coverage was denied because of a breach of a fire extinguisher warranty, which I'm going to go into a little more in depth to explain a bit more. Great Lakes filed a declaratory judgment action in the Eastern District of Pennsylvania. For the non-lawyers, declaratory judgment just means in these sorts of actions when an insurance company denies a claim and the insurer goes out and gets himself a lawyer and sues the insurance company. Very commonly, the insurance company is the defendant. Declaratory judgment action simply means that the insurance company can seize the initiative, file first in federal court, invoke adjunct jurisdiction with everything that means for procedural rules, which in many cases are very advantageous to the marine insurer. So Great Lakes filed its declaratory judgment action, and the insured filed a counterclaim under Pennsylvania's bad faith statute. Pennsylvania has a common bad faith statute, almost every other state has them, that is a one-way statute that punishes marine insurers that handle claims in bad faith. The sorts of things like not adequately investigating, not interviewing every witness, not gathering the proper facts, not doing a proper analysis of coverage. Great Lakes has choice of law clause in its policy, and the Great Lakes choice of law clause is very simple. It says first, federal liability law applies. But if it doesn't, New York law is to fill gaps. So that means Great Lakes filed what's called a motion to dismiss, which says to the court, even if everything that readers said is true, even if we were really bad people and we did a terrible job investigating, they can't make this claim under Pennsylvania law because New York law has to apply. And as had been common for more than a decade before this, the district court enforced the choice of law clause, held that under federal admiralty law, these clauses are enforceable. Doesn't matter that Pennsylvania might have some objection. If this was a policy covering, if this was a life insurance policy, if it was a car insurance policy, if it was a construction liability policy, all of these things would be controlled by Pennsylvania law. And Pennsylvania could have said in that case, we don't like choice of law clauses. But in this case, because it's governed by federal rules, the district court said, doesn't matter what Pennsylvania thinks, doesn't matter what Pennsylvania wants, it's enforceable. Now, I want to stop for a moment here and explain just tangentially the wisdom of the particular clause involved, because these warranties can seem very harsh. In this particular case, the insurer breached a fire extinguisher warranty, which required that the vessel's fire extinguishers and fire suppression system be annually or semi-annually inspected and tagged. So after the vessel suffered grounding, the loss was investigated and it was determined that the fire extinguisher system hadn't been properly certified and tagged. Not even that it was defective, not even that it didn't work. And of course the loss had nothing to do with the fire. All that was established was that the fire suppression system wasn't properly certified. And under New York's rule of strict or literal compliance, this was enough to completely defeat coverage. And I'll explain why this is a very wise rule. Don't think of this case as one about a vessel that didn't burn. Think about it as a case about a marina fire that didn't happen. Think about it as a case about 20 vessels that didn't burn because 1,000 other insurers covered by the same policy faithfully complied with the essential safety requirements imposed by the policy. Being able to enforce warranties like this, which means choosing a law which will enforce them, being able to enforce a warranty means that underwriters it means they can enforce safety provisions that prevent losses in the first place. I heard a little quip once that Lloyd's underwriters aren't just mushrooms growing in the dark, waiting for their heads to be cut off. They are participants. They play a role in setting industry safety standards. And the way we do that is by having warranties like this enforced. Now, the Pennsylvania bad faith claim was dismissed, and the insurer was not happy with that. And the insurer appealed to the Third Circuit Court of Appeals, which is the federal court that sits above the trial court, but below the Supreme Court. There's very little to say about this decision because the Third Circuit basically said nothing in support of this decision. And I'd like to describe the way things went in oral argument. I presented a brief to the Third Circuit describing the history of federal admiralty law, the importance that the founders placed on a uniform body of federal admiralty law that would apply throughout the entire country. Even at the founding, it was recognized that maintaining the broadest commercial nation was vital and that uniform federal admiralty rules were necessary. I explained all this to the Third Circuit, and I get there for oral argument, and the Third Circuit says, yes, Mr. Goldman, that's all very interesting, but what about the Brennan case? Let me divert for a second. In 1972, the Supreme Court held that foreign selection clauses, which are related to choice of law clauses, would be enforceable under federal admiralty law. Following Wilburn vote, there was some belief that choosing the court you litigated would have some effect on what law would apply. So a lot of different maritime industries adopted a foreign selection clause, and in that case, it required that any disputes between the parties had to be litigated before the High Court of Justice in London. And the Supreme Court issued a decision holding that it was enforceable, but with less than ideal language. The Supreme Court simply held that foreign selection clauses would be enforceable as long as they're not contrary to a strong public policy. Now there's that phrase, strong public policy. In the context of the decision, the Supreme Court clearly meant federal public policy. But a lot of courts have misinterpreted that since then and applied it to mean state public policy. So what the insured argued and what the Third Circuit got fixated on in this case was the Third Circuit held that even though choice of law clauses were governed by a federal rule, the federal rule would be that states would always get a veto. So just as Pennsylvania would have a veto over choice of law clauses in a construction liability contract, the Third Circuit held that it would now also be allowed a veto in marine insurance policies. And the only reasoning offered in the decision is this one sentence: we consider it altogether reasonable that the states should have this control. There is not a single reference to any applicable doctrine or principle of federal admiralty law. I struggle to be respectful about it, but that's it. That's the whole decision. Three judges thought it was reasonable to give Pennsylvania a veto. I think the only thing that can be said in favor of it is judges don't necessarily like to have their hands tied. They like to have vague, open-ended rules that give them effectively unreviewable discretion to decide cases based on what they happen to think is just on any given day, as opposed to uniform principles. What it means is when you come to your attorney, when courts articulate rules like the Third Circuit did, it means when you come to your attorney and you say, what is the legal rule? I have to say, well, it's kind of up to the judge. The judge gets to decide that day. If the judge had his Wheaties that day and feels real motivated, he might enforce a choice of law clause, but if he's in a bad mood and he's got an upset stomach, he might not. Who knows? That's effectively what the Third Circuit's rule was in this case. Now, here's the part where I get to say, I get all the credit for winning at the district court. And it means I also have to take the blame for losing at the Third Circuit. The only thing I can say is the Third Circuit's decision doesn't, as I said, does not say a single word about the legal principles involved. You would not know from reading the decision that I even made an argument on the subject, which I take as kind of a compliment. They didn't have a single word to say contradicting the argument I made. They simply ignored me. Next, I get about 90% of the credit for seeing the opportunity here and saying we must go to the Supreme Court. Before I go any further, also, I have to say that the very wise people at Concept Special Risks Limited also get the credit for seeing the opportunity here and for letting us make this petition to roll the dice on this and to try to get the Supreme Court to intervene. And of course, there was no guarantee what the Supreme Court would rule. The decision could have gotten worse if we'd gone to that was part of the risk that was taken. So I owe them a thank you for letting us do this. But as I said, I get the credit for seeing the opportunity here. Although I'm not a specialist in Marine Corps, Supreme Court practice, I've never done anything for the Supreme Court. The one thing I knew from law school is that one of the things that will attract the Supreme Court's attention is what's called circuit split. Federal courts are all divided by region. So what you have here What you had from the Third Circuit's decision was a circuit split. In the Third Circuit, choice of law clauses would be held hostage to state public policy, as opposed to the Fifth Circuit, which is Texas, Louisiana, and Mississippi, which is a fair amount of maritime traffic. In 2008, the Fifth Circuit had ruled that choice of law clauses would be governed by federal rules and that the states could not undo them. So now what you have is, because of this circuit split, you have exactly the same choice of law clause in exactly the same policy, issued by exactly the same marine insurer, but now subject to two different rules. So you have different outcomes on exactly the same facts. That's a circuit split, and like I said, what little I knew about the Supreme Court is that would get their attention. So we filed what's called a petition for writ of certiorari, asking the Supreme Court to take the case. And over the next several months, tension started to build. The Supreme Court would issue a decision every few weeks, every few months, announcing 100 cert petition denials. Because, of course, there must be 1,000 of these every year, and the Supreme Court's taking fewer and fewer every year. They used to take more than 100, now they're down into the 50s and 60s. And every few weeks, another one of these page-long decisions would come, listing 100, 200 cases, cert petition denied. Now, at this point, also, I want to add a specialized Supreme Court counsel, Sullivan Cromwell, was brought in, and they did something amazing what they did in this case as well. And I'll never forget, the attorney for Sullivan Cromwell calls me and he says, "Michael, are you sitting down? You're going to the Supreme Court." The Supreme Court granted the petition for writ of certiorari, consented to hear our case, and restricted it to a very simple question. Who has the last word? Does federal law have the last word, or does state law have the last word? Do states get a veto, or does federal law get to tell the states, you're going to have to take it? You may not like that a party, a big insurance company in Germany that issues policies of insurance with fire extinguisher warranties. You may not like it, but they chose New York as enforceable, but tough, you're going to have to take it. That was the question. Now, faced with that question, the court's decision is very simple. In a 9-0 decision, the greatest words in the English language are 9-0. In a 9-0 decision, the Supreme Court wholly endorsed Great Lakes' position and said that states have no say in that. There might be circumstances under which the federal courts will not enforce choice of law clauses, but it's wholly a question of federal law. The states get no say in it. And I like to put it very vividly like this. Short of secession, no state gets to say, we don't like the choice of law clause in a marine insurance policy. Now, this does leave open the question of whose law can you choose? The Supreme Court didn't directly address the issue. It wasn't on the table, so we have to look to other cases before the Supreme Court. Prior to the Supreme Court, every court that had enforced choice of law clauses, and particularly Great Lakes' clause and the election for New York law, had held that in order to have a choice of law clause, you have to have some connection to the chosen law. It doesn't have to be a lot, but you have to justify why you picked it. You can't just have Michael Bowman stand up there and say, Your Honor, we picked it because it's the most insurer-friendly law. You have to justify it. And previously, Great Lakes in particular had justified its choice of law clause by pointing out that even though Great Lakes is a German insurance company with its underwriting and claims handling agent in the UK, Great Lakes was admitted first as a surplus lines carrier in New York, maintained its agent for service process in New York, and had its American trust in New York. Now that's not a lot of connection, but it's enough the federal courts had held. So what that means is, first, for the marine insurers and the people I told that you need to go out and get a choice of law clause, you can be confident based on these prior cases that if you pick a law to which you have a connection, like the ones I just described with Great Lakes, some sort of physical connection, an office, or the state where you're incorporated, you can pick that one law to fill gaps. Now, the Supreme Court said one other thing on the subject. Commenting particularly on New York law, the Supreme Court said that New York law is a reasonable choice to fill gaps in federal liability law because its marine insurance law is highly developed and well regarded. Technically, this is what the lawyers call dicta. That means it's the court running its mouth a little bit on a subject that wasn't really directly before it. So if you want to be particular, the district courts in the future, when they're called upon to enforce these, don't necessarily have to follow that part of the decision. But a 9-0 decision is about as persuasive as it gets on a point that isn't necessarily binding. So from that, the advice I would give is that you can pick almost any state you want, as long as you can justify it. And New York in particular has been endorsed by the Supreme Court as a reasonable choice for everyone because its law is highly developed and well regarded. Maybe one way to put it is this way: whatever law you choose, don't be greedy. Pick a law that you're satisfied with. You don't have to reach for something obscene. New York law itself is reasonable. It's very insurer friendly. You don't need to go for anything even more insurer friendly than New York. Before I wrap up, I want to talk briefly about Justice Thomas's concurrence. Nothing Justice Thomas said in his concurrence, of course, is binding. No one joined him in it. I just want to add that he does get credit for saying one thing that's completely right. He joined the 9-0 decision, but he wrote a concurrence to point out that Wildren vote was almost certainly wrongly decided, and that it should have been obvious the instant it came out. He gets credit. He's completely right. Wildren vote was wrongly decided. It's always been obvious. Unfortunately, the Supreme Court might wait 70 years before taking another marine insurance case. I think Wildren vote is here to stay. I'd be very surprised if within the life of anyone here, Wildren vote gets reversed. But the lesson to take from this is that you don't need to grapple with Wildren vote anymore. You can circumvent Wildren vote. As I keep saying, instead of having to deal with 50 state insurance laws, and in particular, instead of having to deal with Florida's attorney's fee statute, and instead of having to deal with Florida's anti-technical statute, you can pick one state's law to fill gaps. Finally, for everyone's consideration, I'd like to offer what me and Jim McCanty are proposing as a uniform clause for the entire industry, for at least for marine insurers. This is one of those areas. You're all competitors, but this is one of those areas when it comes to the law and it comes to enforcing contract terms. There's no extra credit for originality. You want to have the same clause with the same words being enforced in every policy, because that means that as you have case after case after case where you deny a claim and your attorney litigates and the court enforces the clause, these things build on each other. You'll get case after case after case. You'll have one district court case enforcing the choice of law clause and enforcing the named operator warranty. And then you'll have the next one, and it'll enforce that captain and crew warranty. And then you'll have the next one enforcing, dismissing a state bad faith claim. And these will build on each other. And as you can see, I've broken it down into each particular clause. This is based on our experience, not just enforcing these in general, but with the way the particular wording is involved. Let me add one more point on that. If I've gotten through to anybody and really are going to go home and on Monday to put that choice of law clause in, it is my strong recommendation that you do not choose the clause that was enforced in the Raiders case. It has to do with the particular wording. The clause generally was held to be enforceable, notwithstanding state law. But that doesn't mean the courts are just going to abandon how they interpret the words. You've got to be very careful with the wording. And this has been worded to defeat certain recent cases that have narrowed the application of the clause. Getting the signal from Captain Chris, so I'm going to I'm going to wrap it up, turn it over to Tito, but in case I don't get up here, I want to add one more thing. I'd like to thank my long-suffering wife, who is here today. She was with me when I was sworn into the Supreme Court in 2014. She was present when the Raiders case was argued. I wouldn't be here without her. She has heard so much about this case over the last 5 years that if I had been sick today, she could have got up here and stepped in and lectured all of you. Yeah, it's all yours. Thank you.
All right, follow. So we really don't know what cases mean until the courts start playing with them and making decisions based on them, although 9-0, pretty strong. But what does it really mean, right? I don't know. Well, I'll just run really quick, but we're talking about federal policy considerations that are running through the post-Raiders cases. There's only a handful, but it's also these topics, these policy considerations are what's referenced in the Raiders case at the spot. But freedom of contract clearly is one of them. Uniformity of maritime law is one that Justice Thomas was talking about so much. And Kavanaugh statement was federal policy. Protection of maritime commerce. You know, the plaintiffs bar, the people opposing these choice of law rules, are attempting to have each different state's public policy dictate the legal outcome instead of the contract. And much of that public policy is evidenced by statutes that a state has passed. And many of them are for the protection of the people or of a particular body group of people. Whereas the Raiders case and these decisions point to the protection of maritime commerce. And I thought that was an obvious significant difference. Predictability reduces uncertainty was stated in one of the cases. Simplified contract management was a federal principle that was leading to low cost and was something that justified and was justified in federal policy. The judicial economy, reducing litigation, aids in dispute resolution, streamline maritime disputes, reducing forum shopping and lowering costs. All of these are federal policy considerations as opposed to the state ones. And the state ones usually, like I said, dictated from a statute, but and those are for protecting the people. And the way the courts were getting around this is using the maritime but local doctrine. You might remember if you study maritime law, or calling the matter inherently local, calling the state public policy a strong public policy. This case just slaps that in the face. Or compelling public policy. And another way to try to get around the application, as you see in some of the cases, is call it a tort case, not a contract case, and therefore, or a tort claim, not a contract claim, and therefore the choice of law rule shouldn't apply. What kind of contracts are we talking about? Obviously, we're talking about maritime contracts. Those are contracts that involve commerce by the sea. Navigation upon navigable waters, maritime employment, but not longshore employment, maritime services or transport. These types of contracts that involve operation of a ship in maritime commerce, or navigation of the ship, management of the ship or its services. Also, where are we seeing the cases? We're going to go through a couple of these cases. But we're seeing the Raiders case cited for not only the choice of law rule, but Justice Kavanaugh's opinion says we will look to the analogous law involving choice of forum rules. And then he says, and the choice of forum rule dictates the outcome in this case, the choice of law case. But anyway, choice of law cases and choice of forum cases, we're going to see the Raiders decision popping up, and that's what we see in some of them. And also, it's not limited to maritime cases. It doesn't say it's limited to maritime law. It's federal policy, and we see some cases where it's applied outside of the maritime context. But when we're talking about maritime cases, we're talking about vessel repair contracts. That's clearly a maritime contract. Vessel financing agreements, ownership disputes over vessels, and that's in Rule B of the Supplemental Admiralty Rules. You know, if you have two owners fighting over ownership of a vessel or possession of a vessel, Rule D is one of the supplemental rules that you might rely on. And that contract is considered a maritime contract. Charters are obviously maritime contracts. Ocean transport contracts are maritime contracts. We may see these sorts of laws in those types of contracts, and therefore applicable. Also, bills of lading. There is a case called the Immobiliary Logger. In that case, the court used the Raiders' decision and affirmed the choice of law clause, but mentioned in it the inherently local exception as still a viable exception post-Raiders. I'm not sure I agree with that, but it was so mentioned. Freight forwarding contracts or maritime contracts into which choice of law rules may be injected. Passenger transport contracts, seamen's wage contracts or employment contracts Michael mentioned it. Husbandry contracts or vessel storage contracts. That is whether it's a wet dock or a dry storage, and choice of law provisions there. And here's, I think, the circuit may say that dry storage is inherently local or not within the court's admiralty jurisdiction. So we've got some cases on that. See where I'm at. Salvage contract. Okay. Salvage contracts are maritime contracts to which these clauses may be injected. And then stevedoring contracts. There are others, but those are just a few that we know are typical, that they have these clauses in the case, therefore may apply to. Now, we have a handful of cases that I found where Raiders has been cited. One of them is this Puerto Rico Fast Ferries case. This involved a master time charter agreement for ferrying two islands near Puerto Rico. This is one of these Puerto Rico Fast Ferry vessels that I found. In that case, the parties did agree to federal maritime law, and the court applied general principles of maritime contract law to interpret the contract. Now, this is a choice of law case, true, but it's also a choice of forum case. And in that case, the reference to Raiders was in applying general principles, that is a contract interpretation. We are in alignment with the master agreement's choice of law provision, which is presumptively enforceable. And so what comes out of Raiders, as I see it, for choice of law and choice of forum cases is courts are looking at it and calling it presumptive, not necessarily even discussing the exceptions that are mentioned. So, and we see that in a handful of cases. This next case I'll mention is the SV Layden case. It's a sailing boat case. And in this case, the charterer arrested the vessel in its dispute with the owner over vessel repairs that were, the vessel was located in the American Virgin Islands. This was an in-realm case, not an in-persona case. The owner stepped in and asserted a counterclaim in the case. The contract between the parties said had a British Virgin Islands selection clause for both foreign and applicable law. Now that's about 4 hours away if you take the ferry, because from where the American Virgin Islands is located. But the plaintiff filed a motion to dismiss the counterclaim because of the wording of the clause in the contract which said that the forum, the British Virgin Islands, was the exclusive jurisdiction for disputes. And so the court citing Raiders said it is well settled that forum select selection clauses in maritime contracts are prima facie valid under federal maritime law and should be enforced unless doing so would be unreasonable under the circumstances. So there it's citing raters and then also quoting from revenue. And the court therefore dismissed the owner's counterclaim similar to the British Virgin Islands to resolve that dispute. The next case that I'll mention is the case in Louisiana, Central Boat Rentals with Harbor Dredging. In this case, Central Boat is a barge owner and they sued the charterer, a dredger, over unpaid invoices. The charterer then third-party, the Rule 14 third-party then the Stolt, which was the project, people that were doing the project, and then under Rule 14 tendered the plaintiff to Stolt to resolve the claims, and then quit paying their lawyers and the lawyers withdrew. In that case, Central Boat was trying to prosecute its claims that would be against Harbor Dredging, but against Stolt as tendered, and there were two different form selection clauses in the two different contracts. And so the plaintiff was arguing that the claims should be bifurcated in some way, but the court said, no, you're going to have to go by the form selection clause with Stolt, which called for Texas law. Enforcing these clauses, the court said, supports predictability, reduces litigation costs, helps streamline maritime disputes, lowers costs associated with uncertainty and forum shopping. The next case I'll mention is McKinney Salvage versus Rigid Constructors. It's a district court case in Louisiana. But this was a salvage suit against a Sunken Barge owner and its insurer over unpaid salvage invoice, or an unpaid salvage invoice. And the raters were cited for the proposition that marine insurance policies are subject to maritime law. And that was one of the sites. The next one I'll mention is the Dogaway case out of Louisiana. This is a case where fire damage was justified more for repairs. The owner made a total loss claim against the insurer who denied payment. The policy's choice of law clause selected maritime law and New York law as gap filler, like the Raiders case did. And on a motion to strike the jury demand, the court cited the Raiders case as removing all doubt of the enforceability of choice of law clauses. Parties to the contract are bound by their agreed terms to ensure legal predictability and avoid disputes over what law applies. Those principles, those policies, and federal maritime law cited as supporting their rules. Next case is interesting because here I can't tell from the decision if it's because the lawyer just didn't argue it well, but it's a California District Court case involving where summary judgment was granted against a cruise line passenger when he made a personal injury claim. He was injured in the shower of this hotel, this lodge, and he had purchased a ticket from Princess Cruise Lines. The package he purchased had 2 nights at this lodge, and he was injured while at the lodge. Citing the Raiders case, the parties agreed that maritime law governs this action pursuant to a choice of law clause provision in the land sea package that the plaintiff purchased. But the court went on to apply maritime tort law, to the claims of personal injury that occurred at the hotel located in Denali, miles from the ship and from any commercial navigable waterway. So the passenger argued in the case that Princess Cruise Line created the hazard, so I shouldn't have to show evidence of actual or constructive knowledge because they created the hazard. Some states' laws allow that. But here the court concluded, au contraire, that federal maritime law does not recognize an exception to the requirement that the defendant must have actual or constructive notice for a plaintiff to prevail on the negligence claim for personal injury. So here, choice of law clause is applying on land rules are governed by Alaska law. The next case I'll mention is an 11th Circuit case that is an employment dispute, wrongful termination type claim from the Northern District of Alabama. The employment agreement had an exclusive venue provision which selected the trial court of this trial in Northern Alabama. Alabama plus Arkansas tribal town is the Indian tribal question. Well, the plaintiff argued that yes, there is this form selection clause, but it's fundamentally unfair under Britain and under citing Great Lakes for the proposition that, the Raiders case, for the proposition that the form selection clause was presumptively enforceable. But the plaintiff argued to the 11th Circuit that it's greatly difficult and unfair for the tribal court to sue the tribal court, to sue the tribe, because the tribal court is non-existent. And the 11th Circuit reversed the case, saying, no, that would be a problem if there is no tribal court. So they said we cannot say definitively whether the form selection clause is not enforceable. That is for the district court to decide on remand with an appropriate evidentiary hearing. And in this, I point out this case, they cite Raiders, it's a form clause where Bremen's kind of prevailing. But I noticed that Bremen's exceptions are fundamental fairness, right? Where there's no reasonable basis for the chosen forum, or that you're being deprived effectively of your day in court. Those are Bremen's exceptions. Whereas the Raiders' exceptions are, we're going to apply the chosen law clause unless there's no reasonable basis for the chosen law, or it violates federal policy. Anyway, the 11th Circuit reversed and remanded that case. Yeah.
I think you would probably consider it safe that a court would take that language from Bremen and say, well, what violates federal policy? If you choose a law so anti-insured that the insured is deprived of the state court, that would probably be considered contrary to federal policy when it comes to enforcing a choice of evidence.
The next case I'll mention is out of Southern District of Florida from June of this year, Seychelles limited case. The plaintiff's insurance policy did select federal advocacy law to apply with New York law as a gap filler for errors. Here, the insurer sued for declaratory judgment after the vessel owner presented a claim under its tender's whole policy, and when the center console went missing while the tender was being towed. The vessel owner counterclaimed alleging breach of contract and breach of the covenant of good faith and fair dealing. And the insurer said, Judge, this calls for New York law, and there is no bad faith under New York law, and that's what that covenant of good faith and fair dealing is referencing. And so the court reviewed the matter and said, yeah, we're granting the motion to dismiss because choice of law provisions in maritime insurance contracts will be upheld in the absence of evidence that its enforcement is unreasonable. And then it goes on to say choice of law clauses are presumptively enforceable. One time. The next case that I'll mention is the Z&G boat case out of Florida. This kind of answers the question about whether the chosen law must be substantially related to the parties and the contract, reasonably related, or rationally related. In this case, the passenger rented a boat from Line Pass, and 2 days later, the passenger was involved in an accident hurting her hand. And 9 months later, she sued the Line Pass Marine that rented the boat, and the insurer was notified of the suit 3 months after that. And then 3 months later, the insurer filed a DA action. And there was a counterclaim. Florida insured sued for damages and for attorney's fees under Florida law. But the court, citing Raiders, held that the choice of law rules, federal maritime law, New York law, was presumptively enforceable, and its narrow exception for when the parties can furnish no basis for chosen jurisdiction. No reasonable basis exception must be applied with substantial deference to the contracting party, recognizing that maritime actors may sometimes choose a law or jurisdiction because the law is well developed, well known, and well regarded, like New York law. Now, the insurer argued that, look, the insurer is a Georgia business organized under Arkansas law, and the accident happened in Florida. It's the insurer is a Florida business, and the claimant is a Florida citizen. Florida law is paramount here. Florida policy is paramount, they argue. But the court said, doesn't matter. Require an agreed-upon jurisdiction to have a substantial relationship with the parties of the contract, rather than simply asking whether the parties had a reasonable or rational basis to select the jurisdiction, would show none of the deference that the Raiders Retreat case requires. It would also undermine the presumptive enforceability that the Supreme Court just announced. I'll point to this last case that I will mention, and it goes, come on now. And it goes Hollywood, Florida. This is a Hollywood, Florida commercial property insurer where, I don't have my notes on it, but this is a claim of insured relating to a Florida piece of property on land, not related, not maritime, but the court decided the Raiders case to enforce the choice of law clause. This was a choice of venue clause, sending it to New York. So now, I'll point this out. I've got 1 minute and I'll do it. I believe that we're teed up for a strong public policy or compelling public policy attack on the Raiders decision. And we might see it in the Florida jet ski library type business with a contract that adopts maritime law and or New York law to be applied in that setting. So I don't know if it's a guess, but I don't think I'm too far off. So with that, you got a question?
I have 2 quick ones. Based on the Raiders, which law can you pick with the choice of law clause? As Peter described, you can pick anything that you either have a connection to or that you have some other reasonable basis for. And as I said, the only thing I don't want to do is that when I'm going into court, I don't want to have to say the only reason you chose it is because it's really great for the insurance company and bad for the insurer. So that means if you've got some sort of connection, either presence, let's say your office or your incorporated, or as Great Lakes has connections to New York, if you're a business surplus lines carrier and you have your American Trust accounts and agent for services process, connections will guarantee your choice, that your state choice is enforceable. And we also know that to apply that other alternative, that there's a reasonable basis, we know that New York is a reasonable choice because its law is well developed and well regarded. That doesn't mean New York is the only one that's well developed and well regarded, but you got it specifically named in the Supreme Court case, which means it's that is as persuasive as it gets for choice. Second, even if states cannot use public policy to avoid clauses at when they're being enforced in court, when states address at the regulatory stage, they can try, and I wouldn't be surprised if they do. States can do 2 things. First of all, state insurance regulators who have to approve forms may try to flat out refuse to allow a choice of law clause. Now, as a constitutional matter, it is absolutely inconceivable that that can prevail. But will that stop them? I wouldn't be surprised if they try. I wouldn't be surprised if a year or 2 from now, the first speaker in the morning here is an attorney who specializes in regulatory compliance. And he or she gets up here and tells a war story about having to deal with a hostile state insurance regulator. It could happen. They also might try, even if you have a clause, state insurance regulators could try to
refuse permission to insert the types of safety clauses that you would want to then enforce under New York law. So they might say, okay, Supreme Court says you can put in the choice of law clause, but I'm not going to let you put in the named operator warranty or the fire extinguisher warranty. Again, as a constitutional matter, I can only tell you that as a matter of theory, it is inconceivable that that can prevail. But will they try? I wouldn't be surprised if they do.
We're not going to take a break yet. We're going to get into the next section. Just two quick things. First of all, I'd like to recognize the 2024 Admiral Club sponsors by name. You can come up and receive a gift. For the writing pad from Progressive Insurance, Rick Stern. Water bottles, Concept Specialists, either Tony Usher or Liam Gilhooly or Sarah Grace Sims. Post-seminar reception, Yacht Club by Steamship, Simone Dana. And another sponsor of the post-seminar reception, Scioli, Alexander Pino, and Frank is here. Frank Scioli, please come up. Thank you again to the Admiral Club sponsors. On a bit more of a somber note, I have your attention. I'd like to take just a minute, I think Jonathan Lundy, you recognized it before, to recognize the passing of a past Fort Lauderdale Mariners Club skipper, past seminar committee, a founding member of the Mariners Club, Art Campbell, left us in December of 2023. You might remember Art was always over here with the speaker gifts. He was 84 years old and passed away in Lakeland, Florida, near his birthplace in Bartow, Florida. As you all know, he was a long-standing member of this club, gave his heart and soul to the committee, to this seminar, and I think that anyone who knows him would agree that this seminar would not have been where it is now if it wasn't for the contributions and the commitment of Art Campbell. He was a proud Scottish Celtic heritage, and he has gone on to Fiddler's Green and Celtic heaven for men lost to sea. And it is said to be the happy land imagined by sailors where there is perpetual mirth and a fiddle that never stops playing for dancers who never tire. Details of Art's amazing career in this industry can be found in your program book. I think Captain Corinth wrote that. So we all miss him. I know Chris does, and Laura, and some of the long-standing seminar committee members. So if we could just take a moment of silence for Art. Thank you. Is it worth it? The science and art of yacht appraisal. As long as there are vessels for sale or damage due to fire, collision, salvage, there's been discussions and questions about valuation by every seller, every buyer, every insurer, every salver, and the subject is not necessarily a new one, but it's always at the forefront, always a question. Joining us for a discussion on this subject are two of the best. First, we have Stephen Knox of Knox Marine Consultants. He's a marine surveyor in Richmond, Virginia. We just celebrated his 37th business anniversary. Steve has worked in almost every aspect of the marine business. I'm sure he can tell you a little bit more about himself. And we also have Jason Dunmore, who has held the title of Florida Licensed Yacht Broker since 1993. He is on an alphabet soup of different marine organizations and committees. He is also a valuation expert. Please give your time and your attention to both of these gentlemen. And again, if you have questions, please download the CVent app. You should receive several emails. If you're not finding it, come see me and I can try to point you in the right direction.
Good morning. Thank you, Charlie. I'm Steve Knox. Jason and I are excited to be here. While we're both appraisers, we arrived by very different routes. I started my surveying career in Virginia in boats are generally the largest thing in the marina. That is, a 70-foot boat is a big boat. Since I started specializing in appraisal about 10 years ago, I traveled to appraise larger yachts and am now very comfortable in the mega yacht arena. Jason, on the other hand, came to appraisal via yacht brokerage here in Fort Lauderdale, where 70 feet is a starter boat.
Yeah, in 1993, I was 23 years old and the youngest guy in a very seasoned industry. And I looked around my entire career at a very seasoned group of people and a lot of wisdom. I always felt like a younger guy. At one point, 30 years into the business, you look in the mirror, showing me fingers on an iPad and parent away from being a pirate in this industry. It happens like that. But it's been an amazing ride.
So we have 55 minutes now to teach you about appraisal. We could talk about it all day, but we're trying to start with a wouldn't, and not cover everything. So we put together the topics we think are most useful to this audience. And if you have questions that we don't get to, please find us afterwards and we'll be here. I want to start with a quick audience inventory. Raise your hand if you're an appraiser. And I include marine surveyors. Surveyors and appraisers. All right, how about attorneys? Lots of attorneys. In the insurance industry, how many adjusters? How about underwriters? Well, lots of you guys. Yacht brokers. Are you all here? Okay, a few. So there's something for every one of those different audience groups here. These are the different types of appraisal assignments. Pre-purchase surveys. We'll go through these very briefly. Jason, you want to talk about pre-purchase surveys?
Well, yeah, pre-purchase surveys, that was really the bulk of my career. This is one where the surveyor really is focusing on the condition of the boat. I think most people understand that they want to know, is the windlass working, are the stabilizers? What's the value of the boat is really, the focus is more on what the actual purchasers are paying. It seems to almost be an afterthought for the pre-purchase, but it is a real bulk of our work.
And then I've had a lot of experience in damage survey, and one of the things there is determining the actual cash value of a boat to settle a first-party property claim. Then there's also third-party claims where the example I always use is a boatyard who has care, custody, and control. They start a fire on the boat and it's a constructive total loss. How much do they owe the boat owner or the boat owner's insurance company? And that's the value of the boat, of course, prior to the loss. An appraisal would be required there. All the attorneys, of course, are familiar with limitation actions. Divorce, I don't see many of those. Of course, that's an occasional thing that an appraiser is asked to do. Diminution of value. Let's go back to the boatyard example. Let's say this fire that occurred is not a constructive total loss, but it's repairable, very repairable. The boatyard owes the cost of repair. Now you have a repaired boat with a damage history as opposed to an undamaged boat. There is some, or is there any reduction in the value of the boat?
This is, we commonly call this ARV or after repair value. And this is, you take a $1 million boat, it caught on fire, which was, it took $500,000 to fix. It's now in the service, undamaged version. But is it $1 million? Put that for a boat show next to a sister ship that is asking $1 million. And this one's just come out of the building, freshly repaired, books were in, audit was firm. There's a diminution value. And the diminution value is basically what it's lost and continuing to.
I'm dealing with one of those right now. It was a 38-foot boat. It doesn't matter. It's still active, so I'm not going to say too much. $500,000 boat was being trucked from the port of Baltimore to a dealer. The driver drove it over a bridge without enough clearance, sheared off the hard top. No real structural damage, but it's going to require a lot of money to repair it, something like $125,000 to $150,000. But then there's a damaged boat. Is it a brand new boat anymore? Well, obviously the dealer would have to sell that at a market value of the boat, not what the owner thinks it should be. Which brings us to different types of value. And I don't like the word worth. What is a boat worth? It really has no meaning, no specific definition. So here are the things, this is how we would prefer to talk about the values of boats.
First of all, value is just an opinion, and the sale price is an actual fact. And the latter can affect the former, but if someone does buy a boat and that amount of money they tender, that is in fact the price, and it doesn't consider that they overpay or is a benefit to their bargain. But it can be a factor in what the boat's value is.
Value isn't just an opinion. That's my opinion. That's not just an opinion. But that's a good point. Value is an opinion, price is a fact. We'll come back to that. Replacement cost new. This is something that marine surveyors are usually asked to include in pre-purchase reports. It's the cost new of an identical or comparable boat, as opposed to reproduction cost, which is an exact duplicate of the boat that's in question. If you're talking about a boat that's still in production, then those two values would be the same. But if you're talking about a wooden boat, then the replacement cost would be the current cost of a production fiberglass boat with the same utility, not necessarily a new wooden boat. If you're talking about reproduction cost, then that would be the cost of a new wooden boat. Probably a lot of difference in those two values in that case. Salvage value.
Yeah, the salvage value is one where we still need to assess what the fair market value is. And as I think people like Larry Washington and the audience can tell you, can get a little complicated if opinions of value are varied. But the salvage value, we need to understand what the baseline was and then determine what the cost to the amount of the salvage thing.
And the fair market value, this is the big one, of course. The short version is, well, a willing buyer, fully informed, would pay a willing seller, also fully informed, with neither being under duress.
Again, this is the baseline. It couldn't be more important for what we did.
And every brokerage transaction, in theory, is a fair market transaction. Sometimes it isn't, but we have to assume that you have a fully informed buyer and a fully informed seller, and whatever price they come to is a market value, absent some unusual circumstances.
And when we have that fair market value, that we can now determine the orderly liquidation value. So the orderly liquidation, it's unique. We started to see more of this in recent years with certain auction sites. But orderly liquidation, the seller is under compulsion to sell, is ordered to sell, but time is not as much of a restriction. And the buyers have more access to the asset. They can bring in their own surveys. Traditionally, in an orderly liquidation, the boat still can be berthed somewhere. You don't necessarily always get a sea trial or a survey, or a sea trial. You can't get your own survey. And the orderly liquidation has a significant difference in the loss of value to that liquidation from the fair market value and a forced liquidation. Forced liquidation is traditionally the federal courthouse steps that Marshall said, going once, going twice, sold. And the buyers don't have as much access to the asset, time, ability, to greatly on the vessel. Traditionally, there's one survey that whoever is forcing the liquidation of it will allow prospective bidders to look at it and look at their home. So there are some differences there, and that has an effect on value.
All right, and then we have importation value.
Yeah, importation value. This is, if you have a foreign built vessel, I think everybody in the audience understands this, but to join the American economy, the United States asks your foreign built asset to pay 1.5% of what the American economy on a boat. the appraisal. These appraisals usually take consideration. If it's a boat that we know is going to take a long time to sell, we can look at that information value. That here would be the proper market value when it's going to sell. And for example, some boats, you get one sale every 400 days. If we know we just had one, you can calibrate that well in 400 days. As the market depreciates, there's a probability for the amount of work. But once that importation value is paid, if that boat stays in the United States, that value stays with the boat, which is a good asset to have. It helps you sell the boat. And you can avoid things like not paying U.S. residents while you use one. So there's some advantages to it.
And then finally, we want to talk a little about scrap value.
Yeah, scrap value is a wild ride. And as the fleets age, I think this is going to become more of a specialty. You're going to find this is going to grow in importance as things, boats age out of class, ferries, freighters, and we have this wonderful product, fiberglass, which we have absolutely no idea how long this stuff's going to last. But scrap really depends on what country you're scrapping in. India is very different than, let's say, Brownsville, Texas, and the United States with EPA laws. The block coefficient that we use to determine what metals are taking out of the EPA regulations and the cost to get rid of it. It is a shifting market and very complicated, but it's incredibly important and going to be important.
Well, let's go back for a more domestic example and talk about the bridge boat. The hardtop was scraped off of this boat, and it's very repairable. But let's say instead of that, the hull had been broken in half, and it was completely unrepairable. That thing still has 3 outboards hanging on the back of it, and those are about $130,000 worth of outboard engines. So that has definite scrap value as opposed to salvage.
Big difference.
Approaches to value. The appraisal industry uses 3 different methods to determine the value of any property. This doesn't apply just to boats. And the sales comparisons we're going to talk about, and this is probably the one where we'll spend the most time, and it's also the one with which most people are familiar.
Yeah, we call them comps, and I think everybody in here, when you buy your house, you're looking at comps. When you're using, in particular pros, you use comps. Comps are a little bit more difficult in Stephen my world because there's no public record for them. So we have to utilize what people we know in our own database and resources. But it's one of the, I think, most important things about a comp is a boat that is for sale is really not a comp. Boat has to have been sold. We need a selling price to create a comparative value.
And a boat for sale as a comparable is better than no comps at all.
Yeah, and you can take a probability if it's a large enough market of supply, and you know that, for example, in the brokerage where we're using sold boats, if you have a mass production boat, and you can see that, for example, Boston Whaler 42s. If 2010 Boston Whaler 42s are all asking $500,000, but every time one sells or one sold, it was 10% less than it's actually sold for $450. But for this particular year, you have a bunch that are $600,000 and you don't have any sales records. You can say with a rated probability it may sell for 10%, just to increase your sample size.
Well, several people asked me at the reception last night, what's the difference between a pre-purchase survey and an appraisal? And this example is a good one. For pre-purchase surveys, the surveyor is going to spend 90-95% of their time determining the condition of the boat, and only this much of their time determining the value. In appraisals, that ratio is almost exactly reversed. There have been probably about a third of my assignments where I've never seen the boat. Sometimes it's not available anymore. Sometimes it's a total loss and just gone. There are circumstances where you don't see that. But this concept of determining what the ratio is between the selling price and the asking price is something that an appraiser would do during an appraisal assignment. That's not the kind of research that most surveyors would do for a pre-purchase survey.
And if I can add one thing to this, when you are dealing with a specific vessel, if you don't have any sales data for the year for which you are trying to assess the value, if you have an understanding of the market trends from the most recent sale you can get, for example, 2 or 3 years prior, and you know that on average the market has lost, let's say 10% a year in value, you can then, with again, a high rate of probability, assess that, well, what it sold for in 2022 and 2024, it's going to be 10% less, whatever the market trend was, value-wise.
And again, this is something that requires a fair amount of research and a fair amount of desk time that a surveyor is probably not going to do in a pre-purchase survey. I had an assignment on a 150-foot yacht for an estate appraisal, and it was one of a kind, so there's no depreciation history there. But I took sales data for boats of the same size and type and plotted selling price versus age. And sure enough, there was a nice little curve that went down pretty steeply in the beginning and then kind of leveled out, or it got flatter as the boats aged. And based on that, I was able to say, well, this boat is now 5 years old, so the depreciation should be X. Haven't been challenged on that one so far. We'll see. Cost approach. Cost approach is the concept of using the replacement cost of the boat and then applying some depreciation based on the condition and age of the boat. If you have boats that are where there's 1,000 of them out there, pick one, Sea 34, then you know pretty much what that boat's going to do as it depreciates every year. But the value that you calculate there is also very dependent upon the rate of depreciation, especially as boats get older. If you have a 3-year-old boat and you apply, well, let's just pick a number, 10% per year, and that's obviously it's going to depreciate more in the first year. But if you apply 10% per year, that's going to give you a certain number. If you apply 9% depreciation per year, it's going to give you a different number, but not that much over a 3-year period. If you have a boat that's 25 years old, and the difference then between a 10% depreciation per year and 9% is going to be huge. So the older the boat gets, the less accurate this method will be.
I agree. Yeah, I don't know why
And then finally, the income approach. The income approach is used a great deal in commercial vessels. The best example are down in the Gulf, where they have day boats that supply boats and passenger boats that supply the oil rigs out there. And they command a certain day rate, so much per day. And that rate goes up and down depending on the state of the market and how much demand there is. If there's half of a fleet tied up because there's no demand, that day rate is going to go down. And subsequently, the value of that boat as an income-earning asset is going to go down. That's usually not the case, though, for yachts. Very, very few yachts are truly income-producing assets.
If you go to the next slide, I'll show you where, in a very rare case, when Parker, Mark Addison, and I were assigned with a gas Russian vessel was seized by a government, and they were doing an orderly liquidation. And on this order, this vessel right here, Ragnar, and on this orderly liquidation, we had very few comps to use. So our sample size of what the fair market value was very limited. It's an extremely odd vessel. We did have a few, but to increase our sample size, it was we decided we were going to use the cost of it. If you go to the next slide, I'll show you what we ended up doing. We knew what the boats on their fair market value, to assess the fair market value, we used the comparative method on the average gross ton, what its comps were selling for, and we knew Ragnar got a fair market value based on comps. But we also noticed that the comps we used, their weekly charter for what they sold in fair market was approximately 1.5% of that fair market. We had a charter rate for ragtime, so we applied the 1.5% of that charter rate to come, just to increase our probability and see if it was in line. We aggregated it to come up with the fair market value. And you can see that we applied what some other vessels that had a quarterly liquidation, what their difference was between fair market value when quarterly liquidation sale took place. But that difference was, when we applied that, come up with a highly probable default, the LLP. And that is a moment in time where the cost approach was
And once again, I'll say that if you have a 45-foot bayliner that's 25 years old, that doesn't justify this kind of research effort. But if you're talking about multi-million-dollar yachts, workboats, then it certainly does. All right, market effects.
Yeah, this is one that in my 30-year career, I've been fortunate enough to witness this in real time. Excuse me. We're living in an age of phenomenal technology. What we're working with from the time we started. Bioclusters have become something that can affect the value of one that doesn't. I've never seen anything lose value as fast when the 4-stroke diesels started being implemented into larger units. When I came into the industry, 2-stroke Detroit diesels were in every boat.
671s.
Then they went to the 692s when they pulled them out. Those are the little firecrackers. Then you could pull 2 of them, and then get 1292s, the 892s. And it was in a whole bunch of ways. The minute we saw these 4-stroke engine showed, loss of value in the 2-stroke was measurable. It was 30%, 28%. It instantly couldn't get it. And then it was time on it increased dramatically. And today we're witnessing one right in front of our eyes. The old satellite technology of the giant domes. Those boats don't seem to sell for as much or as fast as the Starlink. It's something we're witnessing right now. We can measure that as we speak. It's happening in front of our eyes.
And then the smaller side of things, we saw that same change happen with 2-stroke outboards and 4-stroke outboards. That technology was a huge change, and of course it drove the value of boats with 2-stroke outboards down, though that occurred over a little longer time frame.
Yeah, and other things that can affect markets are things like the Great Recession. Again, in
Which one, youngster?
Well, you know, it's funny, like Andrew Silla, the gentleman who I own around, quite often talked about the oil how sailboats just took off and you couldn't sell it. I was playing in the water at that time, not working on it. The way it went about. But the Great Recession was a moment in time where it was like someone took off the switch. For anybody that was in motor sales or even maybe in insurance or surveying, we had a lot of free time. But that was a moment where it was just a massive drop. And I would like to just have one side note. In measuring volume of sales, we have never seen or measured drop in sales from a federal election. From 2000 to the last one, there has never been a measurable drop. No matter what hubris you hear, if my guy, my girl, whoever doesn't, we have never measured it. What does it? Having 2 things, Great Recession and COVID.
Well, there was one other that goes back a little further. A lot of you in here are old enough to remember the luxury tax, late 80s, early 90s. That just killed the large side of the industry. But as Jason said, the most recent one has been COVID. And I'll give you a personal example. I have an 18-foot center console that I bought new in 2015, and I paid about $33,000 for it. Well, my wife is back in the back door, is listening. And in 2021, the boat was 6 years old. I could have sold that boat for what I paid for it. 6 years later, that's how big the effect was, just on my little scale.
Yeah, and so here's an industry that everybody in this room that was involved with, it's the value of boats, yet a lifetime affected only by demand. Was what was voted, what people wanted. That was what really affected the value. In 2019, 2020, that paradigm shift. He had never experienced, and I talked to guys that doing this in the 50s, the Frank Warren's, Gas and Barriers, that business. Nobody had ever seen supply have an effect on boats. It was an amazing moment. And I think to Steve's surprise and mine, we have both been studying the value of boats in a depreciating market. Boats are a depreciating asset. That is just something. Nobody ever picked up the phone and was working in the operator. Somebody said, hey, I've got this pile of money, I want to make more of it. You don't call it that. That's your question. But this moment in time, if you look at this, is an unbelievable statistic that if you see that in the U.S. from between 2019 and 2021, the average value of a boat was 60.5%. International markets, 84.3%. Florida, 69.6%. In the history of the IYBA publishing this data, those digits were always single digits. I've never seen move 8% on a big day, move 5%, and it was usually a minus or a plus, and the value of the dollar more of an effect on that number than anything. This was an unbelievable moment. And it was one of those things, as it was happening, I knew people that were saying, Jason, I'm thinking about offering $1.5 million on this boat. Sir, that boat 4 years ago sold for $1 million. It should be somewhere around $800,000. Well, what do you think? Should I offer $1.4 million? Hear what I just said? And then they would bid and be outbid. It was kind of, I don't know if you experienced it, but you don't know this is happening when it's happening. Because you can't measure the future. You can only take tea leaves and say, I've never seen this before. But when we look in the rearview mirror, we can see this. And I would like to point out why they view the U.S. and Florida. Because the United States is, and I think insurance, actually, people in insurance probably know this better than anyone. But the United States is the giant juggernaut of sales of the world. And in the United States, there is not even a close second to Florida. In fact, Florida, the number of transactions, eclipses many European nations. So we are in, I guess, the heart of where boat transactions take place. And this is also fascinating. If you look at really the sales rate, now this is not accurate data, but it's consistently inaccurate, so we use it. This is just what Sold Boats publishes of the boats that are sold in the United States. I took this sample, and if you can see, really the meat retail is 12,000 boats a year on average, 30 to 50 foot, 1,400 boats, 51 to 80 foot, and about 200 boats on average, 81 foot and up. And that, by the way, those 200 boats sales, there's about 3,000 hours sitting over it. Or a lot of boats fighting each other for those 200 sales. So it's a rough market, it's a ruthless industry. But even in this, you can see this bump in these sales. That, if I went back to 2000, this is just 19 to 24, if I went back to 2000, with the exception of 08, it is a real constant. It's a pretty flat line. It varies maybe 3 to 5%. But boom, we have a moment in time.
Well, the Marine surveyors in late 2020 and early 20, or throughout 2021, there was this disagreement about whether we needed to protect our customers, the boat buyers, from the inevitable deflation of these values. And my position was, they're big boys, and I say boys because we all know how many boat buyers are males, right? They're big boys. If they're paying X amount for this yacht today in 2021, they should know that it's going to depreciate precipitously in the next couple of years. And sure enough, it did. But there was a lot of argument there about should we value these boats at what they're really selling for today as opposed to what the quote, normal market would be.
I just want to take a quick second. If you heard the words he just said, are going to appreciate, in the world of boats, in 30 years, that is not a phrase that ever came out of our mouths until this is an unusual moment. Now, and it is worth also noting that when we do look at, and it's nice when you have large sample size, most of the boats that we're seeing, we did notice in early 23 that if you connected a dot to 2019 and cut out the 2020, 2021, and most of 22, we could see right around April of 22, things started to normalize. And by 23, we were again on a trajectory as if the COVID bubble had never happened.
And this didn't just happen to boats and yachts. This happened across all kinds of recreational products. I'm something of a cyclist, and I had my bike stolen in late 20, early 22, and you just could not find a bicycle. You know, not a good road bike. They just could not be had. I had to go from Richmond to Williamsburg, which is about an hour's drive, to find the bicycle I was looking for. It was just crazy. Same thing happened to camping equipment, canoes, kayaks, any kind of outdoor recreational activity. The market just boomed. One of the things we talked about is the effect of damage history on value. That is the diminution of value. You sheared a hardtop off of a brand new boat because you drove it under a bridge. What effect is that going to have on the fair market value of the boat after it's repaired?
And is the seller obligated to disclose that? If you list the vessel in a using an 9x8 contract, and my partner may know this, but it may be a MIBA contract also. There is a line in there that does say the seller is obligated to disclose material damage. What a wonderfully ambiguous phrase that is, material damage, which we debated quite robustly in the YPA. What is it? And we basically, several years ago, we came to a consensus that it would be breach of hull, fire, or sinking. And in recent times, the consensus has shifted to adding lightning strikes and all that stuff. But this would be the things that we would call damage history. They would add dark value to the boat. And the way that this value, this dark history, can affect the value of the boat depends greatly on how that damage is repaired. It has a huge effect.
Yeah, there are several factors that affect these. I'd like to just run down the list and then we'll talk about each one. The first is the nature and severity of the damage. Next is the pedigree of the repair yard. Is it done in a nationally known or regionally known yard or Bubba's backyard boat shop? How effective and complete the repairs were. The amount of time since the boat was repaired, that is how long has it been in service and how many sea miles does it have now. Did the repairs affect the warranty? And then lastly, the state of the market, that is the demand and availability of comparable boats. So let's start with the nature and severity of damage.
Yeah, when you have something that where the boat's interior is completely burned out, or you had to, it's a total construction loss from trying to bring back. These things, you really are losing a tremendous amount. And we've done some sample sizes on what are the best ways to determine what the repair value would be. For example, the motors to go in the water. To rebuild them will have a particular returning value, but to replace them will increase that returning value. So that is kind of some of the effects of the nature and severity.
Next would be the pedigree of the repair yard. This is pretty obvious. If it's a repair yard that's nationally or regionally known, they're going to do a good job. At least everybody assumes they will do a good job. if, as I said, Bubba's Backyard Boats does the repair, Bubba may do a good job. But if you want to sell the boat outside of that immediate market, Bubba's may not be known very well. And then along with this is how well the repairs were documented. Most major repair yards with a major repair will send pretty complete invoices that describe what was replaced, what the actual repairs were. Ideally, you'd have a marine surveyor documenting the damage and, again, ideally documenting the repairs as they went along. If that sort of documentation is available, it certainly makes the buyer, potential buyer, feel better about the repairs and therefore mitigates the loss of value.
I'd like to add to that. This is a big deal because in the vessels that have been damaged in fire or some breach of law, everything you mentioned, you take any one of them out of there, you are going to lose value after the boat's been repaired. And traditionally, if you have a boat that was never damaged and a boat that was inherited to an from the other one, we've measured somewhere around 30% of lost value is kind of in the zone ±5 of the worst case scenario. You can mitigate that greatly with this step here that he's speaking. If you document the exact amount of damage, and then you document exactly how it's being repaired and who's repairing it with photographs and video, we have watched people, an entire roof was torn on the boat, it caught on fire and seawater came in. Because of the documentation of the repairs were so thorough, amazingly it reduced that loss of value greatly. This is a key step, and it's relatively inexpensive in relation to the amount of value you save.
Exactly. That level of documentation, whatever cost the owner incurs, whatever he spends documenting the value will pay off in a reduction in that loss of value. And this goes hand in hand with how effective and complete the repairs were. Were the repairs made without any regard to the expense, that is, whatever it took was done, or did the boat owner cut corners in the repairs? That'll also affect it. But next is the amount of time since the repairs were made and the boat's been back in service. I had a case of a 55-foot sailboat up on Annapolis that was dropped, slings broke when they were hauling it, and there was structural damage. There was a fair amount of repairs to the boat. But by the time the owner got around to litigating diminution of value against the boatyard, the boat had been back in service for 3 years. It had sailed from Annapolis to the Bahamas, all around the Caribbean, come back to Annapolis, gone to Newport, Rhode Island, and come back to Annapolis. Well, that's a lot of miles. And so any ill effects structurally from the repairs would have been felt long since. So that was a diminishing factor.
Yeah, and this time under the law between the repair and the following sale, if it is repaired and you go to put the boat right back on the market, you may find that one of the biggest problems you'll face is the actual time on the market. And for some of these vessels, it can be $50,000, $100,000 to $1 million a month carry. We did an economic impact study on the average 60-meter yacht back in 2010. That's $26,000 a day. So it would have been in that owner's best interest after a repair to go boating for a while and prove that those refit or repairs work. It would have helped sell this boat sooner.
Well, the next thing that might affect the value would be warranty effects. Have a relative